Thank you. It is now 4:30. We can officially call this meeting to order. Good afternoon, everyone. We are here at Marion Franklin Community Center, so thank you to the folks at the Community Center for allowing us to have our meeting in this space today. Good to see you all. First, we will start with approval of the minutes from the previous meeting. Hopefully, every board member has had an opportunity to take a look at those. Does anyone have any edits or additions? Okay, seeing none, I'd entertain a motion to accept. May I have a second, please? All in favor, please raise your hands. All right, motion carries. Thank you. And now I'll turn it over to Deputy Inspector General, Mr. Blunt, for an update from the IG.
Yes, good afternoon, Madam Chair and board members. Tonight, as she said, Inspector General is unable to make it. We will be brief. You all should have received the quarterly report for the second quarter in your emails, and you should have in front of you the monthly report for the month of July. We have our management analyst, Nate Ryan, here, who's going to briefly go over that with you, and we'll be happy to answer any questions that you have.
Good afternoon, members of the board. So yes, like Deputy Inspector General Blunt said, you have the regular monthly update from the Inspector General, just detailing the number of complaints and investigations for the month of July. And then in your inbox, you should have received a copy of the second quarter report. I'll go over this just very briefly because I know you have a packed agenda and a shorter meeting. So the first thing I'll draw your attention to is the citizen complaint numbers. One thing you may notice is there's actually a sizable decrease in the number of complaints received compared to the same quarter of last year. Normally that would be concerning. However, we are actually seeing the same amount of investigations opened, actually a little bit of an increase compared to the quarters last year. So what we're seeing is actually a higher quality of complaints. So that makes our jobs a little bit easier and helps with the numbers. So down below, you'll see the number of intakes complaints closed at intakes has actually decreased, with a large drop in the reason being for insufficient information, and preliminary investigation found no police misconduct. Since this was just sent to you today, I'll give you all time to review, and we'll take questions at any point.
Sure.
Received with that large of a increase between this same time last year to now, are we seeing, maybe Deputy Inspector, this might be for you, are we seeing that our investigators are more strained in their workloads, or has it been a more centralized process in regards to that?
Yeah, we have increased the amount of investigators that we had. It was yes, sir, it was a strain, but we have increased the total number of investigators to 8. And so we have remedied that, and so everybody has a manageable workload, or caseload, I should say.
Well, I think it should go on note from the board that we commend the staff for, one, the increase, but two, having that large of an increase over a quarter of a year.
Yes, sir.
Then the fact that you all continue to do it and do it well really speaks highly of what the Inspector General and you and the entire team are doing within the office. So I hope I can express that sentiment from the board through Brooke to the Inspector General.
Thank you, Doctor.
Any other questions for the IG? And the IG is at a speaking engagement this evening. I meant to mention that. So she is representing the office, but just at another location.
Association of the Inspector Generals,
Yeah.
ma'am.
Yep.
Yep.
All right. Now I will turn it over to Board Member Younger for a quick update from the Engagement Committee.
Thank you. Two things. This past Sunday, I had the opportunity to meet at the to go to the community meeting at the Faith Missionary Baptist Church with Pastor Lamar, and I had the opportunity to let the congregation know that we do have openings, and that and then I spoke a little bit about the board and the qualifications, et cetera, and the training, and a little bit about the Inspector General's office and how to file complaints. I passed out some cards, and they were all very receptive. and wanted everyone to know that. And then secondly, the engagement committee will be getting together with Mr. Jarrell Black and Stephanie to start working on another town hall. And so I'll update you as we move along. That's it. Thank you.
Thank you. And thank you to committee members who were able to attend. Speaking of our town halls, I do want to put one correction out there from our town hall at Stonewall. We received a question about the number of CIT hours that cadets get when they're at the academy. We mistakenly reported it as 40 standard hours for all officers. It actually is 24. The increase hours is actually the 40. So officers who want to get additional training, that is the 40 hours, 24 is the basic. And we had actually set it, almost inverted it. Also, I will note, we are going to have someone from Chain of Command who is coming to speak at a meeting soon. I also want to note that I hope to hear an update from the Director of Public Safety or CPD generally. At our Stonewall meeting, we had a number of questions about issues that were relevant to the community. And during that meeting, I did state what the status of training hours and curricula were at the time of our safety commission, which was back in 2017. It would be great to hear an update from the Director of Public Safety about what things have changed since then, specifically what things the Safety Commission recommended that have been implemented since then, because a handful of those things have, including when the probation period ends for cadets to become officers, some issues regarding training, different modules, things like that. So it'd be great to hear an update, and hopefully we can get someone in from either the academy or from the Director of Public Safety's office to share what new things have happened since the creation of the Safety Commission back in 2017. All right, with that, we will move to review of pending cases, and it looks like we have one holdover case from Committee 1, 2025-0124. Board Member Nathan, were you going to do that report out? Dr. Jones is on her way, but will be another 6 minutes or so.
This case was involved a CPD showing up at the wrong house because they were using GPS instead of verifying the address by simply looking at the house number or mailbox number. They showed up with assault weapons. They were told that the complainant knocked at the door, opened the door, and what Committee 1 agreed with the Inspector General's findings, but we wanted to make a specific recommendation for a policy change, and that is that police officers need to check the actual address instead of relying on GPS. And last month, I referred to a recent Supreme Court case that had some really similar facts. It was Martin versus the United States. FBI SWAT team showed up at the Martins' home. They were told that there was I think a gang member or suspected gang member at this house. They didn't check the address, but rather relied on GPS. They used a sledgehammer to break into the house, and they also used a flash grenade, destroyed a portion of the home, and then realized they were in the wrong home, created tremendous amount of damage. They hid behind sovereign immunity. It went all the way up to the Supreme Court. The court remanded it back down to the district court, but rejected the sovereign immunity claim and said that it could move forward under the Federal Tort Claims Act. The point is that it just seems apparent that police officers should not simply rely on GPS before they break into a home, and especially using assault weapons. This could have been disastrous. One could imagine a situation in which a homeowner, believing that they were being broken into, would attempt to defend the home, and there could have been, the loss of life, whether of an officer or of the homeowner. So what we want to do is make a specific policy recommendation. There is not currently a rule or policy that requires police officers to check the address by examining the house number, at least the mailbox number, before breaking into a home, instead of relying on GPS, which can be unreliable, as it was in this case. So that's where we went. We agreed with the Inspector General's sustaining of one of the findings, and also finding that one of the allegations was unfounded. We just wanted to add this recommendation. So that's what I'm moving to do.
Okay, may I have a second, please?
Second.
All right, is there any discussion or other question about the recommendation? Okay, so we have, I'm going to keep them separate. We have the recommendation that the Inspector General's findings be forwarded on and accepted as written. May I have a second for that, please? Okay. Starting first with that motion, the case itself, all in favor, please raise your hands. All right. Any opposed or abstentions? None seen, motion carries. Now moving to the recommendation for the additional policy. We've got a first and a second. All in favor, please raise your hands. All right, motion carries. Thank you. Next, we have a case that was assigned to the entire board. I will read out the summary, and we can have any discussion about that. It's case number 2025-0084. In this case, the IG received a complaint alleging misconduct by a CPD officer. The allegation was that during a traffic stop in January of 2025, the officer, quote unquote, wanted me to spread my legs even more while I'm standing there in cuffs as he proceeds to search me thoroughly, up, under, and then the person describes the parts of their anatomy. And that's unacceptable. Upon review, the DIG discovered that the allegation, if true, would be criminal on its face. The IG placed the case on administrative hold, referred the case to Internal Affairs to review the complaint for criminality. That investigation was completed, no criminality was found, and the case was returned to the IG in April for administrative review. The IG's investigation consisted of a review of CAD data, BWC footage, and the IAB investigative report, and a review of applicable CPD policies and procedures. The investigation revealed the officer conducted a pat-down that would fall within the scope of the officer's official duties. At no point does the focus officer conduct a pat-down that would substantiate the complaint's allegations of impropriety. And at no point is there any inappropriate contact with the genital area as described by the complainant. The officer's actions in this incident align with the procedure in CPD. The DIG concurs with the IAB's findings and recommends the case be closed as an administrative closure. Does anyone have any questions?
What case number was that? I'm sorry.
2025-0084. No questions? Okay, hearing none, I'd accept a motion to accept this recommendation as given.
So moved.
Okay, may I have a second? Thank you. All in favor, please raise your hands. All right, motion carries. Okay, turning it back to Pastor Nathan for Committee 1's July assigned cases.
Thank you. This is case number 2024-1570. The complainant alleged that a CPD officer sexually assaulted her. IAB found no criminality. In addition, the charges were filed beyond the deadline that is laid out in the collective bargaining agreement, and therefore the allegation was closed by the DIG with a finding of administrative closure. There was a second allegation that DIG found that the officer improperly used a police platform, which include leads, to check up on the complainant. That was sustained. And a third allegation of assault. This also fell outside the 90-day window of the collective bargaining agreement, and so it was administratively closed. We agreed with the Inspector General's findings in allegation 1 and 3 of administrative closure and regarding allegation 2 of sustained for improperly using the police platform. That's 2024-1570. 2024-1576, this incident arose as a result of the complainant riding his bicycle on the sidewalk and being cited for a traffic violation. The complainant alleged two things. First, that the officer gave him a ticket, and this was, he's saying that it was retaliation for filing a complaint against the officer previously, and second, that the officer advised him to, the complainant, that he needed a license to ride a bike. We had some difficulty with this case inasmuch as it seemed unusual to be cited for riding a bicycle, and we wondered about some kind of retaliatory or harassing of the retaliation or harassment of the complainant. The DIG found that there wasn't any evidence to sustain the allegation of retaliation. In fact, the complainant was riding a bicycle on the sidewalk, and so in that case, DIG found the allegation of retaliatory arrest unfounded, and also there was no evidence that the officer advised the complainant that he needed a license, so that was also, the conclusion was unfounded. While we agree with DIG, it was a troubling case for us in Committee 1, and we just wondered about citing someone for riding a bicycle on the sidewalk, especially given the history of bad blood between the complainant and the police officer. But we agreed with the Inspector General's finding. 2025-0234, this incident arose as a result of a response to a call for assistance by the complainant, who is a Columbus Middle School principal. There were threats from a student at this middle school. Complainant alleged the officer was rude and discourteous due to the race of the complainant and her staff. The DIG found no evidence to substantiate the allegation of discourtesy due to race, and so in that case, the DIG found allegation 1 to be unfounded. But the DIG did add its own finding of rude and discourteous conduct due to multiple sarcastic and unprofessional remarks by the officer, and so with respect to its additional charge, the DIG sustained that charge, and we agreed with the DIG's additional charge in case number 2025-0234. This is case 2025-0252. This incident arose as a result of a traffic accident. The complainant alleged the officer allowed an unlicensed driver to drive a vehicle away from the scene, and second, that the officer didn't provide the information on the driver on the exchange identification form. Regarding allegation 1, the DIG found no evidence that the officer allowed an unlicensed driver to operate a vehicle, and so they closed that with a finding of unfounded. And with respect to allegation 2, the investigation found it's not the responsibility of the officer to verify the information provided on the exchange of information form. The CPD policy simply directs officers to provide the form, but doesn't ensure that they say that the information is correct. And so with respect to allegation 2, they also closed that with a finding of unfounded. We concurred with both of the DIG's findings in case 2025-0252. Case 2025-0295, this incident arose as a result of an officer being dispatched on a call regarding a person with a knife. The officers, in this case, went to the wrong address due to the dispatcher incorrectly entering the address. After loudly knocking and announcing their presence, the officer forced his way in to the wrong home. There were 4 allegations. The officer forcefully entered a residence with his weapons drawn, that the officer placed the complainant under arrest without advising her about why, that the officer searched the residence without her permission, and that the officer swore at her. Excuse me. With respect to allegation 1, the officer explained that he knocked and announced his presence very loudly. He was informed that a light in the basement was turned on and off, believed there to be an imminent criminal threat to people inside the residence. His actions aligned with CPD policy, and so it was recommended that that be closed with a finding of exonerated. We agreed. Second, with respect to allegation 2, the investigation revealed the officer did explain to the complainant why she was handcuffed. It was recommended this allegation be closed with a finding of unfounded. With respect to allegation 3, the investigation found the officer did a protective sweep but didn't search the home. They didn't open any drawers or cupboards or containers or anything else. They simply opened doors and looked through the house to make sure there wasn't anybody there with a weapon, and so the complainant's allegation of an unlawful search was also, it was closed with a finding of unfounded. We agreed with that. And finally, that the investigation revealed at no point did the officer swear. And so it was recommended that that be closed with a finding of unfounded. The DIG found that the officer was unfortunately dispatched to the wrong home, but that error was not on the officer, but on the dispatcher. So we concurred with the DIG's findings with respect to those 4 allegations in 2025-0295. Case 2025-0314, this incident arose as a result of a complaint that a CPD officer was speeding on I-71 South in excess of 15 miles per hour over the speed limit. In addition, the complainant alleged that the officer was tailgating and pushing other vehicles off the road. The DIG found that the officer was in fact traveling more than 17 miles an hour over the speed limit, and so with respect to the officer speeding, allegation 1 was sustained. With respect to tailgating and pushing vehicles off the road, the DIG found no evidence that the officer was doing that, and so they concluded with respect to allegation 2 that that was unfounded. We concurred with the DIG's findings in case 2025-0314. Case 2025-0349, this complaint arose as a result of a traffic stop. There were 2 allegations with respect to the stop: that the officer dragged the complainant out of the vehicle, and second, that the officer searched the complainant near his private parts. With respect to allegation 1, the investigation found no evidence to substantiate the complainant's allegation. The officer initiated a lawful stop. At no point did he drag the complainant out of the car, and the officer did command the complainant out of the vehicle and guided him from the vehicle, but Apparently, the evidence didn't substantiate dragging the complainant out, and so it was recommended that that allegation be closed with a finding of unfounded. And with respect to searching the complainant nearest private parts, the officer did engage in a pat-down for weapons, but there was no, any contact with any private parts was found to be purely incidental, and the pat-down was within policy, and so allegation 2 was closed with a finding of exonerated, and we concurred with the DIG's findings in case 2025-0349. And finally, in case 2025-0376, this incident arose as a result of a traffic collision. Complainant was not involved in the crash, but was called to the scene by a friend. The officer asked the complainant to move away from the crash scene due to exposed electrical wires on the ground because of the crash. The complainant alleged 2 things. Number 1, that the officer got in his face, and number 2, that he threatened to arrest him. Regarding allegation 1, the investigation revealed that the interaction between the complainant and the officer was conducted by at least an arm's length away. He did not get in the complainant's face, and so it was recommended that the allegation be closed with a finding of unfounded. And with respect to allegation 2, that he threatened to arrest him, the officer on multiple occasions asked the complainant to step away from the vehicle, the police vehicle, and did say that if he didn't, he might be taken to jail. The officer had a duty to secure the area. The officer's response was the result of the complainant not complying with officer commands, being argumentative with the officer. At no time did the officer threaten the complainant, and so the officer's actions were found to be within CPD policy, and DIG recommended it be closed with a finding of unfounded. We agreed. So I move to accept the DIG's findings in case number, let me just read them off, 1570, 1576, 234, 252, 295, 314, 349, and 376. And then I'll make a separate motion regarding the additional finding in case, let's see, what case was that?
234.
0234.
Just for clarification, those first 2 cases are 2024 cases, the remainder are 2025.
Oh, I'm sorry, yes, thanks. 2024, and the rest were 2025. So we can, I guess, first handle the motion on all of those cases to accept the DIG's findings, and then we'll move regarding the additional charge that DIG added in case 2025-0234.
Okay, so first, the motion on the cases as given. May I have a second, please? Second. Any questions or discussion on any of those? There was a second here, there was a second there. Pick anyone from this side of me, second. And any questions or discussion on any of those?
Yeah, I think particularly on case number 1576, where board member Nathan talked about our board being a little troubled by that one in particular. My recommendation here would be to potentially hold that case for additional review. Reason being is because I think that part of this outstanding complaint was that there was, an ongoing complaint for retaliation, or the idea was that they were being retaliated against. I think the response from the Department of Inspector General's office was that, well, the individual was violating traffic code and policy, and so as a result, that is a policy violation, and so that should result in that. I think without knowing further information about the other case that is also still open, is my understanding, against that particular officer who is aware of that case, I'm a little troubled to move forward on understanding, because I don't know if that's enough of a rationale to determine whether or not this is retaliation. Very well may not be, but I think there's more review and investigation that needs to be done there. I'd be interested, for example, in terms of, how often that citation is even issued and where I understand that's within the discretion of doing so, but that combined with the fact that that individual has an outstanding complaint against that officer gives me a little bit of pause to make a determination that it is not, in fact, retaliation. I think it's too early to tell.
So you did not agree with your committee, is that correct?
And, well, I mean, I think that was one where we submitted a question to the Department Inspector General to get a response, and so we got that response. Since getting that response, we haven't talked as a team.
We just got the response today, I think. Oh, Monday, yeah. So we didn't have an opportunity to come back together. I'd be happy to put this on pause and withdraw the, we were troubled. But there was at least an appearance of retaliation. The question was, was that substantiated? That was the issue.
Well, and I think the question that we had was, how was there a determination that it was not retaliation?
Exactly.
Because it seems as though, I mean, it could be all coincidental. However, just with the ticket being issued, and there was an open investigation, and then the response was simply, it was a valid ticket. There was a traffic violation. So, I mean, it was a traffic violation. So, I mean, even if it was retaliation, it was a traffic violation.
Yeah, and let's say that's the case, right? I mean, you can retaliate. I mean, there can be retaliation, and it could be a violation. So I think that alone is not enough. I think it warrants maybe additional investigation into that process. Things I'd be interested. I don't know if this is within the full scope of the Department Inspector General, but thinking about how many citations of that type are actually even issued is something that is curious. I think would go into the fact pattern of that determination. But so I think to hold on this one in particular would be my recommendation.
Well, I don't know if we need to necessarily hold. We have Richard here, and maybe you can provide some insight into that case. Do you know, during the interview that took place, if it was asked specifically, was this an act of retaliation, or just the context of that interview with the officer?
No, ma'am, I'm not familiar
Okay.
with I don't have the audio recording. I didn't listen to the audio.
Okay.
Probably at this time, I don't even know if I've seen this case. What I can say is that, based off the facts that we did have and that the investigation that we conducted, it's hard to prove retaliation, right? Mm-hmm. So that's why we didn't go down that road
Okay.
of trying to say that it was retaliation. Our job is to see whether it was a policy violation. And it was a policy violation. I'm sorry,
It was
not a
not.
policy violation.
Okay.
The complainant did,
He had a traffic violation.
yeah, it was a traffic violation. And so, so we could not prove retaliation. So we weren't ignoring that. That's just not for us to say because we couldn't prove it. We didn't have enough to prove that.
Okay.
Yeah, I think that's interesting. I mean, I'd be curious in terms of what steps either the board can take or further steps with the Department Inspector General or the City of Columbus, the Department of Public Safety, because that is a concern, and we've talked about since the creation of the board, is any indication around potential retaliation. Not that this case is determined to be so. I don't know. I think there's not enough evidence to suggest one way or the other. But I do find it curious that was the violation, and there is an ongoing open investigation into another complaint by the same individual. And so I think prior to that even being resolved, I think would be premature to make a determination on this.
Can I amend your motion to withdrawal 2024-1576, just so we can have a separate vote? Sure. Okay. So for now, we'll vote on 2024-1570, 2025-0234, 2025-0252, 2025-0295, 2025-0314, 2025-0349, and 2025-0376. All in favor of accepting those recommendations as given, please raise your hands. Any abstentions? You abstaining on all?
On 1570.
1570. The first one?
We skipped it.
Did we skip that?
Yeah, we held it.
Got it, okay. Then I'm good.
He would need to abstain. And I know he came in late, but I wasn't sure exactly where he came in. So he would need to abstain on the ones that were presented prior to his arrival.
Yeah, I think it might have been 2, 3, 4 or something like that right before.
Yep, I think it was,
taken note and
I
I
think it was
just forgot.
0252 when you came in.
Yeah.
So abstaining on all.
The first 3, 2 of
yeah.
which are being held.
Stephanie, do you have that? Okay.
Just err
Awesome.
on the side of caution.
Yeah, I
Perfect.
appreciate it.
Nope, I appreciate it. All right, and then returning, we've got also an open motion on the additional charge from the IG on case number 2025-0234. May I have a second? Because I don't know that I had one.
Second.
Thank you. Any questions on the additional allegation from the IG? All right, all in favor, please raise your hands. Okay, abstentions? All right, now returning to 2024-1576, I will ask Board Member Nathan, do you want to amend your motion
Well,
on that case?
I'm not sure that I do. Part of it is, perhaps Mr. Tobias could assist us, or Ms. Ross. I don't know what the standards are to prove a retaliation claim. So I don't know how one would meet that burden of proof. So if we're just simply involved in a fruitless endeavor, holding it and then holding it over for next month, I would not want to withdraw it. So I just don't know what are the elements of proving retaliation, and what sort of, not only the elements for proving, for establishing a claim, but what is the evidence necessary to establish those elements? I just don't, I don't know what the legal requirements are.
I think if it wasn't a traffic violation, and you can look at that something differently, but I think because it was a violation.
Yeah, so it's not a criminal violation, so there's not like standard statutory elements because it's not a criminal violation. It could if there was sufficient, again, we use these very amorphous terms, right? Like if there was sufficient information to suggest that the officer was retaliating against the individual, that could potentially be a violation of policy, right? What's the threshold? So they could do some additional investigation pursuant to your ask. It'd be helpful if you could let the IG know more specifically what kind of information you would like her to look for or look into.
Does this have a legal definition, retaliation?
It's more a civil in nature than criminal in nature. Well, there may be a criminal retaliation. I'm just not familiar with that.
But couldn't it also be determined, if, whether it's retaliation or not, couldn't that also be a separate complaint around misconduct if that's a thing?
Yeah, yes.
If I may, in response to the Vice Chair's question, I was looking at the report, and it does say that the officer acknowledged having one other open complaint filed on him by the complainant, but the officer did deny targeting, harassing, and treating the complainant differently due to the open complaint. So while the word harass was not used, he did say he did deny, was asked and denied targeting, harassing, and treating the complainant differently. So I
So
don't
the
know if that
officer
helps.
just happened to intersect with the same complainant coincidentally?
I'll indicate, I just did a very basic Google search, and this is an AI result, so a disclaimer, but it says Directive 8.08 indicates Columbus Police Division says personnel shall not commit or permit discrimination, harassment, or retaliation of any kind. So if that is a legitimate policy within CPD and there's sufficient evidence based on an investigation that would rise to the level where the IG would recommend to you, to substantiate that, then that could be a violation of policy. In terms of what evidence or what's the test, I don't think there is. It's just She does the investigation, makes some professional determination whether there's sufficient information or evidence to suggest that there was retaliation, and then makes a finding, and then you review it.
Yeah, I think that's helpful. I mean, I think there's a number of questions that I'd have as a specific follow-up beyond whether or not the individual committed a traffic violation, which is specifically with regards to that officer. So he certainly, was he aware that there was a outstanding complaint against him? Which he was, right? And so we know the answer to that question. That's not dispositive, but that's helpful knowledge. And then two, I mean, other steps in terms of, again, that goes into the pictures, how many of those citations are even issued. I understand that's within discretion, but that combined with having an open complaint against one, at least it warrants, I believe, a further investigation or review. It may end up being nothing that substantiates it, but I think there's some further questions that we could certainly send back to the Department Inspector General for further review.
So we've got an open motion and a second on the floor. We've had discussion. Board Member Nathan has not changed his motion. I will call the question to vote, and we will see if it carries.
I just don't know if we're going to, if the Inspector General is able
They're
to.
certainly not going to look
do
into
that.
it if this gets voted on.
No, I understand that, but I don't know if they're,
Further into it, we have to let them know specifically what they need to look into. And it seems as though, you know, if there wasn't a traffic violation, then, okay, there might be an instance of retaliation, but right now, because there is, that is plausible. But then now you're looking at the officer's word versus the complainant's word, and it's, I mean, it's.
Well, I think a question is that we don't really know is like in the lead up to that happening. I mean, there's not a whole lot in terms of what led up to that particular moment. Was this person, and again, I don't want to go into the world of hypotheticals of something that I don't know the information on, but I do think at the very least we could do some further investigation to get more of that information in terms of the process without, I think it's a helpful question to ask.
What they could look at would be the interaction between this particular officer and this particular individual, so that they could look at the open complaint to see, was it a valid complaint? Did he also break the law in that situation? And then, and take a look at the validity of that, and then take a look at this one, and see, but if there were only those two interactions, I guess you could also check to see, was there a third interaction between these two? But if it was just those two, like Dr. Jones said, and it's just the officer's word and the individual's word, and he did break the law, I'm not, I don't know.
And it might be, but I think the thing is we don't know,
We
right?
don't-
And I think
right.
at the very least, I would want to err on the side of let's do some additional investigation. They are already investigating another open complaint. They're in active investigation of an open complaint. And so what happens if we move forward with this and say, no, there's no sort of retaliation, and then
so, Carl, would you specifically, I mean, my struggle is,
Yeah.
what would you like to direct the Inspector General to do to specifically for the investigation? Like, what are we asking the Inspector General to do?
Short of the officer admitting that it was retaliation, it's going to be difficult.
Yeah.
And the officer already said.
That's my,
Yeah, I still think there's further investigation and review. For example, the other outstanding complaint that is, how about this? At the very least, I think it would be premature to issue this was not retaliation prior to knowing the end result of the other, or even more
we'd
information.
like to direct
Yeah.
I'm willing to go along, for a pause, but I just think we need specific guidance to the Inspector General, like what would be sufficient, like what are we asking? So are we asking them to look at the other complaint? And what are we asking them to do?
Yeah, I'd say look at the other complaint, because in the response to why it was not retaliation, the answer was there was a traffic violation.
Yeah.
It wasn't anything beyond that. And I think it is worth reviewing the other outstanding complaint to determine whether or not there are factors that would substantiate a complaint of retaliation or misconduct by this particular officer. That would be the best version of the language that I can immediately, to the top of my head, think about doing. I agree that any sort of potential retaliation has to meet a specific standard in terms of that's hard to substantiate. And it very well may not be, but I think more factors should be looked into.
Well, I'm happy to pause for another month. I don't know that will still meet the threshold.
Yeah.
But if the Inspector General is able to find out about the other complaint and report back to us that, what was the nature of the complaint? Was this their first interaction? Maybe there's something in the complaint that there's been a series of negative interactions. We don't know anything about it. There's Board Member Strickland is concerned. I don't have a particular need to determine that this month as opposed to next month, so that's fine.
So would you like to amend to withdraw your motion? I
Yes,
think that's probably the cleanest thing to do.
Yeah.
All right.
sounds good.
Motion withdrawn. All right, turn it over to committees 2 and 3 for their case report outs.
All right. Case number 2024-1066. This is a misconduct allegation. The complainant said that the officer stopped him and asked him if he sold drugs, searched him, touched him inappropriately. Specifically, the complainant alleged that the officer sexually fondled him by trying to look for something up his behind with his hands. And 2, the complainant alleged he was harassed and called a drug dealer by the officer. The investigation consisted of an interview with the focus officer, a review of information received from CPD IAB, a review of BWC footage, review of CPD legal advisor update, and review of policy and procedure. Pertaining to allegation number 1, the investigation found that the CPD Sexual Assault Unit and the IAB completed their investigation and found no probable cause to support the finding of a criminal charge. They recommended that this case be classified as unfounded. The DIG agreed with the IAB findings. Additionally, the DIG investigated and found that the pat-down frisk conducted that led to this complaint was proper and within CPD policy. Therefore, they recommended that this allegation be closed as unfounded. Pertaining to allegation number 2, the investigation found no evidence to substantiate the allegation that he was harassed and called a drug dealer per BWC. Therefore, it is recommended that that allegation be also closed as unfounded. We reviewed it, and we agree with both findings of the Department of the Inspector General. Second case is 2024-1560, and this is an allegation, let's see. Oh, the allegation is, number 1, the CPD officer would not provide his name and badge number. Number 2, the individual was searched. The complainant's car was searched without permission or probable cause. And 3, the officer was aggressive, and he placed the complainant in handcuffs and twisted his arms in an aggressive manner. The IG's investigation consisted of an interview with the complainant, an interview with the focus officer, a review of CAD data, review of BWC materials, CPD policy and procedure. During the course of the investigation, the DIG discovered that the officer violated policy by failing to keep his BWC on during the entire interaction with the complainant. With regards to allegation 1, 2, and 3, the investigation found that the CPD officer did not violate policy and procedure. At no point during the incident was the officer asked for his name or badge number. The complainant gave permission to the officer to search his car during the traffic stop. The complainant followed the commands of the CPD officer and was placed in handcuffs. There was no evidence that the CPD officer aggressively placed the complainant in handcuffs or twisted his arms per BWC. Therefore, the DIG recommends the finding of unfounded for these three allegations. However, the DIG has their own allegation where there was evidence that the officer failed to keep his BWC on during his interaction with the complainant. Another officer's BWC footage revealed that the focus officer turned off his BWC while he was still interacting with the complainant. Therefore, this finding is sustained. There is a finding of sustained for this allegation. We reviewed and we do agree with the allegation, with the first three allegations of unfounded and with the sustained allegation that the Inspector General brought about. Number 3, 2025-0119, this was a, a complaint brought during a domestic violence call. The complainant alleged that the officers failed to properly investigate a domestic violence incident that occurred between her husband and her adult son. The investigation consisted of CAD review, ECC review, a review of body-worn camera footage, review of home security footage and photos from the complainant, a review of arrest and witness documentation, review of applicable policies, and also review of Muni Court materials and case information, a telephone interview with the complainant, and in-person interviews with all the officers involved. With regard to allegation that the officers failed to properly investigate the domestic violence incident, the DIG investigation found that the police response and handling of the matter was within CPD policy. Therefore, it is recommended that this allegation be closed as unfounded. We did review this and found that we do agree with the Inspector General. Let's see. The next case is an allegation that, number 1, an officer did not call for medical attention in a timely manner for the complainant's son who had been struck by a vehicle. Number 2, the officer was rude when the complainant asked for medical attention for her son. He rolled his eyes at her. And number 3, the officers did nothing to the driver of the vehicle that struck her son. Additionally, the complainant alleged an officer did not remove her son from the cruiser or remove the handcuffs from her son in order for the medics to treat him. The investigation consisted of CAD report, review of BWC footage, and a review of policy and procedure. With regard to allegation number 1, the investigation found an officer made a request for medical assistance shortly after arriving on the scene and as soon as the scene was secured. Therefore, it is recommended that this allegation be closed as unfounded. With regard to allegation number 2, the investigation found no evidence that an officer was rude. Officers that interacted with the complainant used the same tone and demeanor that they used with each other as they did with her. There was no proof that one of the officers rolled his eyes at the complainant. Therefore, it is recommended that this allegation be closed as unfounded. With regard to allegation number 3, the investigation found that the traffic report was completed and policy was followed. The involved parties provided conflicting stories and neither had corroborating evidence. Therefore, it is recommended that this allegation be closed as unfounded. Okay. The next one is case number 2025-0279, and this is a complaint that the CPD officers, 1, used force on an assault victim, number 2, threatened to arrest the complainant, 3, threatened to mace the complainant, and 4, placed the victim in handcuffs, although they were advised that he was the victim. The Columbus DIG investigated this by interviewing the complainant, by interviewing all the witnesses, interviewing the 2 focus officers, 2 of the focus officers, reviewing CAD data, reviewing BWC footage, and policy and procedures. The investigation found evidence to substantiate the complainant's allegations. However, CPD officers followed CPD policy and procedures. CPD officers used a level 0 use of force on the victim to place him in handcuffs for the safety of everyone around him. Therefore, the DIG recommends a finding of exonerated for allegations 1 and 4. They had to use handcuffs on this individual because, as a matter of fact, I went down to look at the BWC on this case because it was a little fuzzy as to what happened. And after viewing this, I can explain what happened here, but let me finish the summary. With regards to allegations 2 and 3, the investigation found no evidence to substantiate that a CPD officer threatened to mace or arrest the complainant. Due to the officer's safety concerns, one officer did warn one of the witnesses of the consequences of their continued actions. A warning issued by CPD is not a threat within policy. Therefore, the DIG recommends unfounded as to allegations 2 and 3. The complainant in this case got into a fight with someone and fell. He hit the back of his head, and there was bleeding from the back of his head, so he had to be taken to the hospital. What had happened was he had seized before the officers arrived, and when the officers got there, he was in bad shape, and he started, as they tried to put him on the stretcher, he was started to fight them. And there was a large crowd that was getting close to the officers, and they were taking pictures with their cell phones and trying to tell the officers how they should attempt to put this officer on the stretcher, and they were telling the medics how to do their jobs also. The people in the audience were advising the officers that they were trying to protect the rights of the individual, but if you look at the BWC, in reality, the man was bleeding from the back of his head, and they were trying to get him to the hospital as quickly as possible. And the officer advised them that they were interfering, and they were trying, all the medics and the officers were trying to get the people back so they could get him into the ambulance, thank you, and get him to the hospital. So after viewing this and discussing it, we absolutely agree with the Department of the Inspector General in this case. The officers did not violate policy or procedure. And I have 2 more. Case number 2025-0374. This is an allegation of misconduct. The complaint stemmed from a mental health episode where the complainant's son was experiencing such. The complainant alleged, 1, the officers did not take any actions to pick up the complainant's son during a mental health episode while she had an active probate order on her son. The DIG's investigation consisted of an interview with the complainant, an interview with the focus officer, review of BWC footage, review of CAD, and review of policy and procedure. The investigation found the officers did take actions to address the complainant's son's mental health episode during this incident. The officers made contact with the complainant's son, ensured that he did not need police assistance. The officers' actions were supported by policy and procedure. Therefore, the DIG recommends that this be closed as unfounded, and we did concur with the IG's findings. And the final case, this was a complaint of misconduct. The complainant alleged that an officer violated his rights and abused his power by placing him under arrest for driving without a license instead of detaining him and looking into the situation. The investigation consisted of attempts to reach the complainant, a review of the DIG Smart Sheet submission, review of of CAD materials, review of BWC materials, and policy and procedure. With regard to this allegation, the investigation found no evidence to substantiate this allegation, and it is recommended that this be closed as unfounded. And we reviewed this and agreed that we agree with the finding of the Inspector General. So, there's only one, so as to all these cases, case number 2024-1066, 2024-1560, and then the rest are 2025-0119, 0265, 0279, 0374, and 0389. We motion to accept the findings of the Inspector General. And as to case number 2024-1560, the DIG allegation substantiating that, we also move that this be accepted by the, we motion that this be accepted.
Okay, I've got a motion on the cases. First, may I have a second, please? Second. Okay, may I also have a second on the additional allegation from the IG on case number 24-1560?
Second.
Yes, the sustained. May I have any questions first on any of those cases? Okay, hearing none. We've got first and seconds on all of those and the additional allegation. All in favor, please raise your hands. Any opposed or abstentions? All right, motions carry. Thank you. All right, and I do believe we are going to have a motion from Board Member Nathan to move into executive session, so I will.
Yes,
leave
I'd
the
like
floor
to
you.
move that we move to executive session.
So there's specific requirements and rules to do that. There's
Okay.
certain limitations, so can you provide some general understanding so I can see whether it fits?
It really has to do with the way that we're using our time and recommendations for a change in the specific allocations of our time in our board meetings.
So I'm looking at the Ohio Attorney General's Sunshine Laws Manual relating to executive session. There's 8 or 9 articulated reasons why you can go into executive session. I heard kind of general rumblings about the potential for executive session, and I was looking at all the different articulated reasons, and I thought the only one that potentially would fit would be certain personnel matters when particularly named in the motion. What you've just described to me doesn't fit into that category, and so it seems like those issues would be things that would just be discussed in a regular open meeting.
Okay. What are the other options or spaces in which executive session is used? And then I'll let Board Member Nathan decide if we just want to then have it as open discussion.
The other ones are purchase of sale or property, or sale of property pending or imminent court action, which as far as I'm aware, there's none, hopefully, or I would be in the loop by now.
Right.
Collective bargaining matters, matters required to be kept confidential. And it says here, to discuss matters that federal law or regulations or state statutes require the public body to keep confidential. I don't think that would apply here. Security matters, hospital trade secrets, confidential business information, or an applicant for economic development assistance, and Veterans Service Commission application. So I don't think any of those apply. Under the first one, which I mentioned, which was the personnel matters, you know, even there, I was kind of scribbling and doing some research while the cases were being presented, because this talks about considering, and I'm paraphrasing or cutting it short here, dismissal, discipline, promotion, or demotion of public employees or officials. You're not public employees. You're technically public servants because you're an advisory body. So, you know, if I gave it the broadest definition possible, there could be some argument made that you're public officials to be able to talk about some of these things in an executive session. But again, from what Board Member Nathan indicated, I don't get the sense that that's kind of the nature of the discussion.
Okay. So there's no personnel matters, right, in the motion?
it would impact public, I mean, not, you know, as we discuss things, that could be, it could be perceived as implicit critique of public officials, but that's not,
That's right for public discussion.
yes.
I'd be happy to have that conversation. I think there are maybe specifics that maybe a committee can have further specific conversations on in terms of among maybe an ad hoc committee and then broader to the broader board. But I don't know if those are still open meetings, right? So I don't know if there are any specifics here that you want to talk about.
I know the
in executive
agenda
session.
used to have a section here at the end to talk about like policy, but I don't see that here. That category at the end would be something where whatever you're talking about, that's where it would be appropriate to talk about those things.
Well, then that's what I want to talk about. So that's fine. I mean, we don't have to go into session. We can have a conversation about policy.
Okay.
So, several of us have been serving on the board since the inception, Board Member Younger and Jones, Board Member Strickland, and Chairperson Brooks and myself. And that's been, how long? 4 years? 4.5 years?
4 years, 4.5, yeah.
Something like that. So during that time, we've reviewed hundreds of cases and taken a considerable amount of board time to review those cases. The statistics are such that once we've reviewed all of those cases, and there are findings of sustained in a relatively small percentage. The most recent quarter, according to this report from the Commander Lip, is that we had 229 findings, and it resulted in 37 recommendations of sustained by the DIG. That was reduced to 1/6 of that, 6 department findings out of 229, so less than 3%. So we're spending an enormous amount of time. It just reminds me of a factory in which everyone is really busy. The Department of Inspector General is doing a great job. We've got investigators working really hard. Then we are taking all of their work, reviewing all of that, generally agreeing in 98, 99% of the cases. We then forward that to the chain of command, and those findings are whittled down to 1 or 2%. At least that's what it appears in terms of any kind of sustained discipline. So I've just wondered if all of the activity that we've been engaged in over 4 years in terms of board meeting, not in terms of community engagement, education, all of that, is time well spent. And so, you know, the Safety Commission, that was a predecessor to this group, came up with something like 80, 82 recommendations. They moved on, I think, about 50 of those. And 32 of them, there's no website that is currently available to examine the state of affairs regarding the other recommendations. What I would love us to spend our time doing as a civilian review board, since we're civilians, we're volunteers, would be to engage in a discussion of policies like the Safety Commission policies and find out, track those recommendations, make other recommendations for policy changes. I have no problem personally reading the cases each month and just basically saying, yes, that this is fine, unless there's any kind of issue, just raising those at the board meeting. But I trust Board Member Youngers and your committee to do your job, and I would be happy to do that. But it's the policy recommendations, at least for me as a board member, serving for the last 4.5 years, the time that I've had the most satisfaction is when a policy recommendation like the one I made about special duty officers using body cams or covering people who are unclothed, or if we have this recommendation that police officers have to check addresses. It feels like, as a volunteer civilian board member, that we're making a productive difference for the sake of our community, doing what I signed up to do. This just doesn't seem like a productive use of all of our time as volunteers. I mean, it's taking quite a bit of time to both read, review, discuss, re-review here, and then it's whittled down to a vanishingly small number of cases in which these findings are sustained. So I just wonder if we might want to, rethink what the board is spending their time doing. Since, again, we're volunteers, we have a limited amount of time. Most of us have real jobs that, are taking a lot of time. And if we were, for example, my proposal would be to take a look at the Safety Commission, break it, those recommendations down. They were in 4 or 5 different categories, training and so on. Board Member Ford might say, I would love to take a look at police training with 2 other people. And what are we doing? What were the recommendations? Why were some of these things not sustained? Are there other recommendations that we could make? We would divide up that work and have a meaningful conversation for an hour of our board time around policy to incrementally move the ball forward in terms of the work of this committee, the work of this board. So that's my recommendation.
Do both.
Well,
Because what you're saying is excellent. I'm thinking, the way we got to that, 2 things. And I'm just thinking now.
Yeah.
We're talking. We owe it to that 70, to the citizens in Columbus, the city of Columbus, to review their cases in the way that we do. I mean, to do that review. We do that,
Yes.
we have to do that somehow.
Yes.
I don't know how,
Yes.
but somehow. And then number 2, how did we get to that, the body cam? We did that by reading the cases.
Precisely.
By us talking in our committees, and then by bringing it here and discussing it, and we thought, we've got to, look at these cases
So,
here, we've
yes.
got to have this
Yeah, we did it
off-duty.
inductively, for sure. We examined the facts by reading the cases. So Mary, I'm not suggesting in any way that we dispense with the reading of the cases. I'm just talking about the use of our time
Yeah.
for the 3 hours that we're together monthly here, that we're taking the vast majority of the time, at least in my experience over the last 4.5 years, the vast majority of our time is spent doing what we just did. Reading out the cases, all of us basically agreeing with what the Inspector General does, but also with the committees, what we do. Occasionally, there's an objection. It would just seem like that amount of time could be significantly reduced, and that, you know, and that we would expand the amount of time for policy discussion. And my suggestion about how would we get to the policy discussion, a potential starting point would be the Safety Commission recommendations, in which we would break those up and say, okay, there's 32 left. We don't have to tackle 32 in a month. We could tackle 3 each month or 2 each month and just grind through those, make a recommendation, for example, of more transparency on what happened to those 32 recommendations. Why is that not accessible to the public? Like, I don't know how to find them, and I'm on the Civilian Review Board. I don't know how we track the progress of those recommendations. So something that would get us more in the policy direction and less of our time would be spent doing this. So, yeah. So I see our secretary doesn't like that, but I do.
I'm writing this question down.
Oh, okay. Oh,
Are you suggesting committees, maybe? I mean,
Well,
how do
if
do
we
it?
got
It's a
to the
good
second
idea.
part of the conversation about policy discussion, that could be broken down just the way we have it now with Committee 1 and Committee 2, and just say, what would you be interested in taking a look at? And likewise, in our committee, similarly, we're already having a conversation as a subcommittee. Let's move beyond just reviewing these cases and having a conversation about, policies, so that not everything arises simply from these, but rather the Safety Commission did a tremendous job on behalf of our city, and we would push that ball forward, so.
Are we required to read these cases out at this meeting, or could we change that format to Pastor Nathan's point, where we come as a committee knowing that we reviewed them and say, Committee 2 presents case 25091, 25092, we concur with the recommendations as presented from the IG, the end? Or do we have to keep reading each one and going through that process?
Yeah, there was discussion about this a year or so ago, and I think
Before
I
my
may-
time, TV,
I
before my
may-
time.
Before your time, and I may have even recommended that. But I think there was a consensus from the board that it was a good exercise to read through the narratives in the meeting for transparency, for accountability, for thoroughness, all the above. There's no delineated process for how these meetings run. I mean, the generic language in the code is, review, investigate, review. It uses all those kind of generic terms. So it's up to the board to decide how you want to use your time at these meetings. If you want to try to be more efficient or change the format, that's up to you guys to talk about and vote on.
And I'm just suggesting perhaps a review of our prior decision, inasmuch as we, have lots of experience doing these things, and we find ourselves essentially agreeing on 98% of the cases. And so we could, to take Board Member Anderson's question, we could say, we want to read those cases where there's a disagreement out, to have a conversation about why we disagreed with the DIG's findings, so that there's some more robust conversation. But where there's agreement with the subcommittee and the DIG, it just feels like we're spending a lot of time that is not taken up with something that might be more productive for our city, and that is policy.
I'll make an observation. Oh, sorry.
I was just going to level set for Board Member Anderson's transparency comment that your committee meetings are still open to the public, where you are having these discussions about each case. So it doesn't necessarily have to be this meeting where you're choosing. If you're going to still review cases, you can do so in your committee meetings, which are open.
Just to highlight a couple of things before Board Member Anderson joined the board, and probably before some others as well, when we've had this conversation in the past, what we have always run into is many members of the public do not make it to the subcommittee meetings, and so for some people, this board meeting is the only place they actually can access anyone talking with great substance about their case. And so if someone were to come to this meeting to figure out what's happening with the case that is being reviewed, because the cases are posted, so people know what cases are up for vote, and we don't have even a summary, and it's happened before. We've had community members come before on board member days. Then there is a feeling of, well, the board doesn't care about my case, right? So we've had those discussions. We've also, I asked pointedly the last time we had this discussion, is every board member willing to read all the cases? There has been hesitation on that regard, because if all we're doing, because let me just by example, today, the one case that Subcommittee 1 actually had agreement on, at least that's the way it was proposed initially, we spent 15 minutes on. We have 37 cases next month. And so if that is the way that we want to do it with a reading out of numbers, then it really will require board members trusting the people in the other committees and taking that. Without that, then we may have open discussion about 37 individual cases, and the hope to have a true policy hour may not be realized. On the policy piece, I will say that since at some point last year, I'd have to look back at my notes to see when we started it, but I started reserving time for our policy discussions. And very frequently, those policy discussions are quite short-lived in their actual discussion. I open the floor, ask people what would they like to discuss. From those meetings, we've had ideas around who do we want to have come to a meeting and present to us, and we're having those things happen. I am not opposed to following up on Safety Commission recommendations. I was a member of the Safety Commission. Many of those recommendations are mine. However, we've had open opportunities for people to start other subcommittees to do some of this ad hoc work, and we have not had any follow-through with those committees actually being formed. And so my point being, we currently do have a training subcommittee. Dr. Jones is the chair of that subcommittee. We currently have a community engagement subcommittee. Board Member Younger is the chair of that subcommittee. I am the chair of our Rules and Regulations Committee. So I do think that is an excellent idea. I do not know that we have settled on a thing that this board will actually do when it comes to how we review, report out cases. I'm open to revisiting. However, I do not think we can say that it is a waste of our time. If we actually read through our cases as we've been doing, at the beginning it was a struggle. It took our committees a very long time to read out their cases and give summaries. Y'all have gotten a whole lot better with it. At the same time, that readout today only took, if we would have taken out the one discussion about that case, it would have been 45 minutes to get through all however many cases that was.
15.
Yes, 45 plus the 15 on that one case. So there is space to have these policy discussions. There is space to follow up on the Safety Commission recommendations, but it would require us to do that additional work.
I think there's, in terms of capacity, I think did you have an observation? Okay. In terms of capacity, I think that's where there's some potential challenges. So for example, to your point, board member Nathan, like the public data dashboard, for example, as an opportunity for us to actually react to. I think there's a reason that those policy discussions are short-lived often is because most of our time is spent on reviewing the cases. And so
No, that's what I'm saying. And we can go back and look at the meeting minutes. There have been plenty of times where our meetings have stopped either at 3:30 or 4, and we had another hour.
That's not what I'm saying. I'm not saying you didn't reserve the time. I'm saying the reason that they're short-lived is because most of our members' time is spent on reviewing cases. We have not spent a lot of time as members to basically say, here's some policy ideas for us to review and react to as a board. That's something that I think the chair ultimately would have to endorse in order for us to have that conversation. Because I think right now, and I'm grateful and I appreciate that we've set aside time to have that policy conversation. And I'm grateful that we've have the opportunity to discuss this now as a board, as a group, because the incentive structure right now is just to talk about the cases, and there's not a lot of room for, we're going to dedicate X amount of time to policy.
So just to finish up, Chairperson, or at least to respond to what you're saying, it isn't just the time spent here in this room. As a subcommittee, if it was assigned to us, Subcommittee 1 is going to work with Dr. Jones to talk about training. And there are 4 issues that the Safety Commission recommended that were not implemented. Well, we would be able to have that conversation with Dr. Jones. Why were those not? What's going on with training? You're the expert. What's happening? Or something else. And we would come to the board with some recommendation. We've had this conversation. We would like to have a further conversation with the entire board, or any of the other issues that the Safety Commission recommended. I'm not suggesting that, by the way, that the only ground or the only basis for policy would be the Safety Commission recommendations. I was just saying that's a starting point. You guys did a lot of hard work. 40% of it never was implemented. Why?
I think we can do both. I think I go along, I think that what Brooke said, we can do. Just like today, we could have gone on, and we could have finished in 45 minutes, and that 15 minutes could have been accomplished in 5 minutes by just saying, hey, this case needs to be tabled, and we'll come back, we'll ask this question, instead of repeating and repeating and repeating. And we just can't, we just have to figure out how to get through our 37 cases next month in a reasonable period of time, and then allow, we have 2 to 5, we have 3 hours. Maybe figure out a way that we can we can give the people what they deserve, which is to have the cases read and not just case numbers read at them. Because that's not what we signed on, that's not what I signed on for, to read case numbers to people. I signed on to read what happened and how we feel about it and how we came to that decision and what the Inspector General did. That's what I signed on for.
I signed, I'm here because I think it's about impact and looking at the outcomes, because I think
we can do both,
we
Kyle.
can, no, I agree. Look,
let's not just talk and talk and talk over cases and kill them.
I'm not talking about that.
Let's give an hour and a half to reading the cases, an hour and a half to policy, and be prepared for policy, so that when Brooke says, okay, policy, then why don't we, when we meet with our committee, figure out a way, discuss policy and be prepared.
We do that, right? I just think in terms of where the priority is set, it is not on policy. It's on individual cases. Point being, I've been talking about this dashboard thing for the last year or so, and there are a number of challenges to actually implement that. I'm excited about the steps that the Department Inspector General is taking to review in the process. But that shouldn't just be on the Department Inspector General's office. There's roles that us as a board, that City Council, that the Mayor's office as Safety Director could play a role in terms of making that stuff more publicly available. But that's just not up on a list of priorities. But in terms of something for us to react to, that's a concrete example of something that we could react to. And that's why, folks ask about why there are a set of cases that have just abstained from, is because the process that we're moving forward, yes, we can review and get done through the cases and not have any discussion on those cases. But at the end of the day, if it still whittles down to 1% of cases actually resulting in any sort of change,
And I want, it's not 1%. So
okay.
So,
Maybe it's
yeah,
6 or 7
I'm
or-
gonna ask Dr. Jones to finish her statement, and then I will give some data on our 2024 case numbers, because it was not just 1% that resulted in sustained action.
So I was actually going to just address the comment about the priority, and I don't know how recently everybody has familiarized themselves with the charter, but the charter of the Civilian Review Board explicitly states that the board shall, the priority, receive, initiate, cause investigation of, and recommend resolutions of complaints filed with or initiated by the board. So the priority of the board is to review the complaints in the cases that come before the board. That charge is very different from the Safety Commission. The Safety Commission was established back in 2020 or a little bit before that to review the Division of Police because there were a lot of issues at that time. And so the purpose of that, the commission was created to identify what those issues were and to offer recommendations. We did that in parallel with a consulting group called Matrix that came out at that time. So there were two types of recommendations. There were the recommendations that came from Matrix, and there were the recommendations that came from the Safety Commission. Now, there was follow-up with all of those recommendations in terms of the ones that had been tracked and addressed, but then there were reasons behind why the other ones were not. And there's actually a document out, I can't find it, but I will, that provides the reasoning why those remaining recommendations weren't addressed. A lot of times it just wasn't feasible given the laws and limitations and policies and procedures that were implemented at that time. And so I think, we have committees here, and we probably, should have a conversation about, who's going to serve on the various committees, what the roles and responsibilities of those committees are. But what I don't think we should be in the business of doing is recreating the Safety Commission.
I think specifically the charter amendment that you did mention also includes in that amendment the charge of us looking at patterns and practices. That is.
I have the charter right here.
Yeah, and it is in there about patterns and practices.
It's not.
What the full amendment doesn't
I
include
just read
language
you.
Patterns and practices are in our bylaws.
It's in the bylaws.
Not
That's not the
not
charter.
in the charter.
in the chart in the
I
charter
just read
amendment
you
that
the
was-
charter.
That was the complete amendment.
Yes.
And I will say that of the 2024 cases that were sent by our board to the chain of command, where there were 96 sustained allegations of misconduct. Of those 96 sustained allegations, CPD is still reviewing 14 of them, 82 of them, we've gotten responses back. Of those 82, 58 of them, CPD agreed with the findings as they were written and either engaged in positive corrective action, documented constructive counseling, written reprimand, or dismissal. We had one dismissal of an officer following one of our cases. That's still going through arbitration, so there's no telling whether that dismissal is going to remain effective. There were 24 disagreements of those 82 cases. And some of those cases, even though there was a disagreement with the ultimate finding, officers were still reprimanded or still got some sort of discipline. The disagreement may have been either over a process or some other issue, but they still receive discipline. And then the others are spaces in which CPD chain of command disagreed. Based on kind of the early part of 2024, when the IG went back to chain of command and said, hey, we don't like the fact that we sustained a finding here and you all didn't, can you tell us more about that? They added an extra layer of review because of the fact that even chain of command recognized that some of the places in which they disagreed with the IG's findings may not have been appropriate. And all that to say, at some point last year, maybe earlier this spring, I asked if there was a specific policy subcommittee, Mr. Strickland, that you would like to work on and work towards. And I don't know that I've ever said no to a specific committee that anyone has wanted to start on the board. Technically, under the bylaws and our rules and procedures, I'm the one who gets to put the members on the committee. So if there are folks who want to work on a policy committee or a more specific ad hoc committee, as long as the board says, yes, we want that committee, then I get to appoint who gets to serve on that with you. And despite having that offer and asking if that is a committee that you wanted to form, it hasn't happened yet. And so my point is that changing the structure, and we haven't really bore out how we would even do the policy part when we've been given the opportunity, is a bit frustrating.
Burns, I've laid out in written form, as you've requested, as others have requested, options that we could take to actually have this as a setup in terms of reducing the number of subcommittees, for example.
That's not the
which
part I
which-
mean.
Which we've done.
I mean the actual, like, having a committee that talks about the policy stuff. That was offered to you.
This is part of what we've been doing around the steps for the data policy, the data dashboard. For example, that is a policy recommendation in terms of the data dashboard, so we can actually track consistently. And specifically, in terms of, in addition to the charter amendment piece, part of the bylaws and the, passed through city code, city ordinances, is looking at the patterns and practices around policy. And I would just say the weight of where we have focused our time has often been on the individual review, which we need to do, and that's the charge, especially with the Department Inspector General, that we have the powers to do so, should also be on these patterns and practices. We just haven't spent a lot of time on that, and that goes beyond any one committee. And so I think perhaps this is something that we can include within each of our committees, is that, in addition to reviewing the cases, you read those out, maybe there's an opportunity, if there's any if your committee has any policy recommendations, you can add that in, and kind of have that as part of, your discretion to communicate whether there are or so. And then I think with, Board Member Nathan, who's leading a review committee, maybe you can think about in terms of how you structure, when we present out these cases.
But isn't that what we have already been doing, though? Because we review the cases in our subcommittees, we identify policies and practices based upon what we continuously see come up with the complaints, and then we propose the policy. That's how we got to the mandated body-worn cameras for special duty officers.
But I think it's where I think it's the time allocation. I think it's just like thinking through what is the best structure for allocating our time each month, and which is a fair point. I mean,
just,
I don't know. I think there was a conversation for executive session for discussion, but.
So I'm hearing a couple of things, Chair Burns. Number one, I guess I just had a couple of questions. What percentage of the 2024 cases were sustained?
I don't have what percentage of the overall cases were sustained. I have, of the 96 sustained allegations, what did chain of command do with those sustained allegations thereafter?
But that 96 is the denominator of a much it's the numerator of a much larger denominator. I'm just asking what the percentages are.
I don't have that right in front of me.
In front of me right now, I have Commander Lips' first quarter figures for 2025. And there were 229 recommendations from the DIG's office. Of those 229, 6 were sustained. So that's less than 3%. So I don't know 80 sounds like a lot, but I don't know what the denominator is, like what percentage of cases. So that's what I'm getting at. It's that there's a tremendous amount of activity going into 6 sustained findings. I mean, it just is a lot of activity. Yes.
Just real quick, I do want to give you some background on those numbers. Just when we do them, when you guys vote on, we don't have the numbers back from chain of command yet.
Yes, we do.
They're not not all of them. You'll get the 229, but we don't have the recommendation from CLC until we get it back. Those are the only ones we've gotten back.
Okay, well, whatever
That's
we've
why-
gotten back,
That's why we still
Okay.
have 14 allegations from 2024 that we still don't.
I'm not I'm just saying what maybe this is an outlier and that these statistics aren't representative, but if they are representative, It could be fluid. Are you suggesting these are not representative?
They're,
Go
they are
ahead,
very
Mary.
fluid. When the IG, so you guys voted on something today, so we're gonna go back and we're gonna enter them. It will be our data. We don't know when we're getting these back from COC. So if you're looking at the COC numbers, you're looking at what we already have. We don't have everything back from them. You did 229, but they haven't reviewed 229 yet. Does that make sense?
Yes.
They said, the department said that they reviewed 229 allegations.
Was that, okay.
That's what their numbers are saying.
Yeah.
Of their numbers, I'm just taking their numbers, of 229 department findings, they sustained 6. Okay?
They still have 67 that's in the chain of command review.
You see this here?
So there's still more that needs to be reviewed. So these numbers are fluid.
Okay.
Well, I mean, let's say, so I do think one potential opportunity here is just in terms of like the follow-up of like how we actually get this information across. Is there an openness to, I know we've been having these town halls, I think they're great, I love these flyers as well. Is there an openness in terms of whether the board wants to, create a survey of some sort to the residents of Columbus, or I don't know, anybody, safety director, about effective, impact or what they would like to see from the board or policy?
Sorry, I don't mean to interrupt, but is it the board's general consensus that you all want to continue to do what I'm hearing a lot of pushback. So do you all want to continue to do the meetings the way that we're conducting them? Because if you all think this is the most productive way to do the meeting, then I'm outvoted. But if you say, gosh, maybe we could restructure, I'm just suggesting some level of restructuring our time together and some thought about how could we get into meaningful policy conversations. Maybe it wasn't the safety commission, maybe it's something else, but I'm just suggesting.
I think everybody
Madam.
is open to what you're proposing.
Oh,
but
I was
think we
hearing a
just-
lot of pushback.
Well, because I think we just need to figure out what it would potentially look like. What would that structure look like? And how could we do it with still honoring and recognizing and reviewing the cases, but then also creating that structured space for the policies? I think, we might need to create a subcommittee to even come up with what that looks like.
Madam Chair, I think for me, I certainly agree with Pastor Nathan that there is a more excellent way to do the meetings and the report out of the cases. What I am always intrigued is, and I can only speak to the committee in which I serve, like we don't come to this meeting to question the reports coming from our committee. So to me, it is, if we're all reviewing the cases and we're having the committee meeting and we're attending our committee meeting, when we get here, we really should just be doing the IG summary, because we should be flowing through the cases because we've talked about them, we've read them individually, we've talked about them in the committee meeting. There should be rare chances or rare times when we come to this table and ask a question about a case that our committee or that my committee has had. I think that then adds on, Pastor Nathan, to some of the time we spend, because now we've got a question about a case that our committee has already looked at. So now we've got to answer the question for that case, and get it back on the floor, and then it arises to other case questions. But to Vice Chair Jones's point, we have to remember that what our mission and purpose is. And if the charter says that our mission and purpose is to receive those complaints and issue statements in regards to those complaints, then policy change is a byproduct of doing our mission and purpose. So I don't think we can minimize one to get the other. We have to do what our mission and purpose is pursuant to the charter, and then allow for those policy questions and recommendations. I think the body-worn camera, as we have seen in some of our cases, has exonerated, or I think that's the right one, exonerated a lot of officers. Sure. So we see that where that policy is. And then I think we also got to deal with our sphere of control. Once we make a decision, we're not the body that deals with it at chain of command. I think that, and I think they're going to have a host of different opinions and thoughts about our decision. It doesn't mean that our work was invalid. It just means that because of the way this was set up in terms of the FOP and however else it was negotiated across the board, we don't have that secondary level like some cities do to be able to control it once it gets into the police department's hands. So I think that, A, making sure that we do mission and purpose and allowing policy or whatever other recommendations we have to become the byproduct. 2, following through that, our committee work is done and that we attend our committee meetings and we come here and we report our IG summary, and perhaps from after we've had a committee 1 or committee 2 has made a report, then we may need to say, Brooke, Madam Chair, you may need to say, are there policy recommendations that you've seen in your current review that you want to bring to the board? And holding the committee accountable. What policy recommendations are coming out of your committee that you want to put on the table? And maybe, Pastor Nathan, that helps us do our mission and purpose, but it also drives us to a policy discussion because the question goes on the floor every time. What policy recommendations do you have coming from committee 1? And then what policy recommendations do you have from committee number 2? Then we have our cases, our mission and purpose, and the byproduct always rises to the top. Just as a,
I just would have,
because I agree with you.
I just have a slight objection to your point, right? Because I have no problem with public discussion and conversation and questions about cases, whether it's within your committee or outside of it. And I think we should have the space to have those questions in the public eye. We also have the space during our subcommittee meetings. Those are opportunities to bring up for further discussion for board members to talk about and to discuss a set of cases. Whether those discussions go long, like that's part of the job that we signed up to do and be a part of. And so I take a little bit of offense to your suggestion that asking questions as somehow we're not attending, members, I don't know, you never said anybody by name, right. But that members are, somebody is not attending meetings or whatever, or if they are, they then ask questions among their own committee. I think we should have those discussions and conversations. That's not the issue for me, that we talk and debate and have things. I know some people have concerns about talking in circles. The issue is about impact and whether or not the cases that we do move forward on have any impact outside of after we've sent them over to CPD. I think there is a role that we can play as a board to actually check in to see what the residents of Columbus are looking at and whether or not the board is being responsive to their needs. I want to also be very clear. The concerns that I have are not with the Department of Inspector General's office. I think they've got a full team of investigators that are reviewing cases, that are investigating time in and time out, have a huge team of energy and resource that are going into it. I think they are doing a tremendous job. But I think ultimately, we do this process a disservice if, as a board, all we do is review, move it on, and say it's out of our hands and it's now on to CPD. There's not much to it. We're just going to keep the factory moving to the next cases without having deeper discussions or urgency about who's keeping track of these things more publicly. I think that's a disservice. And so that's where my concern is that we have not, like, the conversation around like presenting to city council or anything like that, like no one seems to be pressed here that we don't have some sort of publicly available dashboard or that we don't have some sort of way to track what's happening with our board day in and day out beyond the agenda that's online. I think I understand that things take time, but this board has now been in formation for 4+ years. There's some concrete things that we should at least stress to have completed by the end of 2025.
I'll just note, because in the conversation about impact, one of the things I also did was looked at the cases or looked at the policy recommendations outside of the cases that we made where things have actually happened. So the body-worn camera being purchased was one thing, and then we had to go back and have another recommendation about actually making that policy that they wear them mandatory, and so that has been changed in policy so that it is mandatory. We do have an amended mental health response policy worked into how officers respond because of one of our recommendation. We do have an updated ASL policy, albeit it's not as far as we initially thought it would be, but then we had a discussion about making our recommendations more specific. We've also got a next of kin notification language update. We also have an update to how officers should respond and what materials they should have with them when they have an unclothed person in their car. So thinking of impact, I do want to say it does take a little legwork, but there are ways, especially if you look at the quarterly reports and you read through them that we get back from Commander Lip, you can see the things that they have done because of our recommendations. However, it does take a little legwork to do. So again, I am not opposed to having committees delve more into policy issues. I do, however, want, if that's what we're going to do, for it to happen. And so to this end, we need people who want to say, okay, then I will look at, our committee's going to look at this, or we would like to look at this, or we'd like to create an ad hoc committee, and then we need to follow through and actually do that.
And I 100% agree. I think what you just listed out, I agree. I do not believe that the board has no impact. I want to be very clear. But in terms of communicating that impact publicly with the public, I think there's some opportunity there. And so perhaps we also issue press release, report, whatever it might be, that's something from the chair and the vice chair. However we can support on doing that, we can certainly make that happen.
Is there anything else that any board member would like to put on the floor?
Committee chair will come with policy recommendations next time.
Looking forward to it.
Won't you, Ms. Mary?
All right. Do you have anything, Ms. Brock?
Reminder about next month.
Okay, go ahead.
Oh. I was gonna ask you. So next month, you all did receive an invite. So at 1 o'clock, we will be having the citation ceremony. It's for all the 4 people who actually finished their terms, their full terms for the Civilian Police Review Board. So that's gonna be Miss Janet Jackson, Reverend Tatum, Mr., oh my gosh, Mac, I don't know, I call him Mac, I can't think of his name right now, Willard McIntosh.
Yes.
And Mr. Fluharty. So at 1 o'clock, there'll be refreshments and things, and then your meeting will start at 2. You know what?
All right, unless there's any other business, I'd entertain a motion to adjourn 7 minutes before we have to allow our tech crew to actually have time to clean up.
Second.
Okay, all in favor of adjourning, please raise your hands. Meeting adjourned, thank you.